Ready, start. It is not in dispute that executive instructions issued by the government have given them the right to claim the pay scales so as to be on a par with the government employees. Stop. The question is, when there is no statutory values issued in that behalf and the institution at the relevant time being not in receipt of any grant in aid, whether the writ petition under Article 226 of the Constitution is not maintainable? Question mark. In view of the long line of decisions of this court holding that when there is a interest created by the government in a institution to impart education, which is a fundamental right of the citizens, the teachers who impart the education get an element of public interest in the performance of their duties. Stop. As a consequence, the element of public interest requires regulation of the conditions of service of those employees on a par with government employees. Stop. In consequence, are they also not entitled to the parity of the pay scales as per the executive instructions of the government? Question mark. It is not also in dispute that all the persons who filed the writ petition along with the appellant had later withdrawn from the writ petition, and thereafter the respondent management paid the salaries on a par with the government employees. Stop. Since the appellants are insisting upon enforcement of their right through the judicial pressure, they need and seek the protection of law. We are of the view that the state has obligation to provide facilities and opportunities to the people to avail of the right to education. Stop. The private institutions cater to the need of the educational opportunities. Stop. The teacher duly appointed to a post in the private institution also is entitled to seek enforcement of the orders issued by the government. Stop. The question is as to which forum one should approach. The High Court has held that the remedy is available under the Industrial Disputes Act. When an element of public interest is created and the institution is catering to that element, the teacher, being the arm of the institution, is also entitled to avail of the remedy provided under Article 226. The jurisdiction part is very wide. Stop. It would be a different position if the remedy is a private law remedy. Stop. So they cannot be denied the same benefit which is available to others. Stop. Accordingly, we hold that the writ petition is maintainable. They are entitled to equal pay so as to be on a par with government employees under Article 39D of the Constitution. Stop para. As would be evident from a reading of the aforesaid decision and the paragraphs extracted above, the principal question there was whether the petitioners were entitled to claim pay scales equivalent to and at par with the government employees. Their claim before the High Court was rejected with the observation that it would be open to those teachers to institute proceedings under the Industrial Disputes Act. The view so taken was faulted by the Supreme Court upon noticing that the executive instructions which had been issued by the government did give those petitioners the right to claim pay scales at par with other government employees. Stop. Additionally, the court noted the rights conferred on the petitioners to claim equal pay scales on the basis of Article 39D.